Welcome to Law and Chaos. We've got a great show today. We're going to talk about the Biden administration's moves to protect both workers and your right to smoke up. And we'll be catching up with some of the Trump land lawyers who flogged election lies in 2020. A little, where are they now?
And why aren't they in jail already?
It's an extremely fair question, and we will answer it. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. We made it through yet another week. With me today is my good buddy, Andrew Torrez. Andrew, how are you?
For the first time in a long time, I am great, Liz. How are you?
I am great as well, and so happy to see you. All right, so as we've said for a couple weeks now, we're changing up the format of the show, and actually, I really like working with you, Andrew Torrez. Who knew? So would you consider sticking around permanent, like?
I would love to do that.
Cool. Done. Let's fucking go. Okay, let's start off with a quick update on Trump's trials because Trump has now joined the New York Contempt of Court Club.
To be fair, he was already a dues-paying member after being held in contempt by Justice Engoron in the civil fraud trial because, Trump couldn't stop summoning troll storms against Justice Engoron's law clerk.
Oh, that's a good point. This ain't his first rodeo, but I think that was maybe a slightly different type of contempt because Justice Juan Merchan can only assess a penalty of $1,000 or jail of up to 30 days, and I think it was like $15,000 by the end.
It was definitely more than 1,000. Yeah. So under New York state law, there are essentially three flavors of contempt, right? So first, you have to ask whether the contempt is civil or criminal, which means whether you're trying to deter future misconduct, that's civil, or punish an existing violation of a court order, that's criminal. And civil contempt is what Justice Engoron imposed on Trump. And that provision is much more open-ended than judicial criminal contempt, right? The judge can impose larger fines and jail sentences, whatever is necessary to, make the contemnor behave, right? And it might seem a little counterintuitive, but here the district attorney sought the narrower application of criminal contempt. And that was smart because this was the first batch of violations, right? And the court was always going to be cautious. I don't know that there was a judicially bulletproof record to show that civil contempt was necessary, right? And so that's why the DA cited the provision of the Judiciary Code. It's Section 751 that, as you mentioned, limits Justice Merchan to only $1,000 a pop or 30 days in jail.
Got it. Okay. I mean, I would like it to be more. You would like it to be more?
Well, I think we're going to get there. So one last bit of geekery before you take us into it. I said there are three flavors of contempt, and that was two. So that's because there's also an entirely different criminal contempt law in New York. It's New York, right? And that is New York Penal Code's 215.50. That's a misdemeanor for disorderly, contemptuous, or insolent behavior committed in the court's, quote, immediate view and presence. And then there's 215.51, which is a Class E felony, and that's for threats of physical danger.
Well, I mean, I think we've seen ample evidence that Trump has put witnesses, jurors, and the judge's own family in actual physical danger.
No argument there. But if DA Alvin Bragg wanted to charge 215.51, what he'd have to do is issue a separate accusatory instrument that formally charged Trump with a separate crime. That would result in scheduling an entirely new trial, right? And the prosecution would bear the burden of proof beyond a reasonable doubt as to all of the elements. So, Trump would have the right to a trial by jury. And
No. We're not going to slow this thing down, right? Justice Merchan is not going to slow this thing down. That's not going to happen.
Yeah.
Okay. So let's talk really briefly about what happened Tuesday in Justice Juan Merchan's courtroom, which is obviously that the court found Trump in contempt. The judge did not buy the bullshit arguments that retweets are not endorsement, so it's just fine for Trump to quote articles at the New York Post calling Cohen a serial perjurer as long as he doesn't say, these are my personal thoughts from my orange head. And the court did not agree that there's like some kind of unwritten exception to the gag order that allows Trump to post responses if they're political.
That's because their argument was literally that adding MAGA to a shitpost about Michael Cohen made it, quote, political.
Yeah, so surprise, that didn't fly. So for 9 of the 10 offending posts, the ones that the district attorney moved for contempt on, the court agreed that Trump was in contempt and fined him $1,000 for each of the posts, which, look, the court acknowledged is not enough to restrain a billionaire. That's like saying, you better not do it or I'll fine you a nickel to anybody else. But it does lay the groundwork for actual real consequences in the future.
Yeah, I think we both agree that Justice Merchan made it, pellucidly clear that the next stop is a holding cell, right? Let's quote from his order. He says, however, the judiciary law, that's the criminal contempt, does not vest the court with authority to craft an appropriate punishment when a $1,000 fine will not achieve the intended purpose. While $1,000 may suffice in most instances to protect the dignity of the judicial system, to compel respect for its mandates, and to punish the offender for disobeying a court order, it unfortunately will not achieve the desired result in those circumstances where the contemnor, that's Trump, can easily afford such a fine. In those circumstances, it would be preferable if the court could impose a fine more commensurate with the wealth of the contemnor. In some cases, that might be a $2,500 fine. In other cases, it might be a fine of $150,000. And then concluding, because this court is not cloaked with such discretion, it must therefore consider whether in some instances jail may be a necessary punishment.
Yeah, so we do agree that if Trump continues to violate it, he is going to find himself inside a cell, but not immediately, because 2 days later, on Thursday morning, there was yet another contempt hearing over 4 more violations. So that was Tuesday when the order came out on the last batch of violations. And then Thursday, there was another contempt hearing. And look, it's pretty clear that at least 2 of those, the comments about the jury, are going to get another contempt finding. But those statements predate Tuesday's contempt order, the order that we're talking about. So, look, I don't think he's going to get jail for that, because I would assume that the clock basically starts for any new statements made after Tuesday, April 30th, when the original contempt order dropped.
Yeah, I agree entirely. And, so far, to his minimal credit, Trump hasn't violated that gag order in, what is now 2 days and counting. Although it must be pointed out that at one of his stupid rallies, he did attack Cassidy Hutchinson, which definitely violates the parallel gag order issued by Judge Tanya Chutkan in D.C. So, it's only a matter of time before he's back at it.
I didn't even see that about Cassidy Hutchinson. Wow. What an idiot. Yeah. Right, because that's the only thing that Judge Chutkan retained. She stayed the rest of it, but she said she retained jurisdiction over the gag order. No kidding. Okay, so let's talk about the other Trumpland lawyers, because in our written post yesterday, we caught up with Ken Chesebro, election lawyer extraordinaire.
One of the things that really surprised me as we started to see the documents was John Eastman has always, kind of taken credit or blame for coming up with the cockamamie fake elector scheme. And it turns out, when you read the memos, the real intellectual firepower there was Ken Chesebro.
Yeah, and maybe by coincidence, maybe not, one of those guys saved his own hide and pled out, and the other one just got disbarred, so go figure.
Yeah, John Eastman, smartest guy in the room, if you ask him.
And if Ken Chesebro's not in the room.
Yeah, but counterpoint, Eastman has raised nearly $1 million on the MAGA equivalent of GoFundMe. So, maybe I'm the dumb one here.
Yeah. All right. So, okay. For those of you who haven't read that post, and actually we talked about John Eastman's Go Grift Me Too before, but Ken Chesebro was a super nerd lawyer who hit it big in crypto and decided to become a Republican weirdo instead of just like a nebbishy dude parked in the Harvard Law Library his entire career. So after the election, he reached out to offer his services to the Trump campaign, specifically with respect to the fake electors. So he claimed to be resting his legal reasoning on the dispute over the elections of 1800, where there was this argument over the validity of the electoral certificates, and then also the scenario in 1960, your favorite, I know, Andrew, where Hawaii had 2 slates sworn in because there was a recount underway, and it was pretty clearly going to give the state to John Kennedy.
Yeah, invite me back and push all my buttons. No, that's fine. Look, the Hawaii scenario would not have been dispositive anyway, since Nixon would have lost. even if he'd won Hawaii. And the Hawaii legislature actually certified that second slate of electors. And the electors didn't meet in a porta potty in the parking lot of the State House. And
yeah. Okay. So it's clear from Chesbro's memos, he wrote all these memos for the campaign and they kind of evolved. So he started maybe with Hawaii as a template saying, okay, if there's if one of the legislatures changes the certification or a court changes its certification, but that's an ocean away from where he ended up. No state legislature or court actually switched any swing state electoral votes from Biden to Trump. And then Chesbro had to come up with new stratagems to keep Trump in the White House until he wound up with, it's totally cool for the VP to unilaterally reject electoral certificates and decide the outcome of the election. So, that's some serious real estate that he covered in his evolution. Yeah. Chesbro has only been indicted once in Georgia in the Fulton County RICO indictment. And he asserted his right to a speedy trial in that case, presumably hoping that DA Fani Willis would blink and drop the charges against him rather than have to present all her evidence twice, right? Once with him and, whoever else asserted a speedy, and then with the larger group that included Donald Trump.
Yeah, and the only other defendant to assert their speedy trial right was Sidney Powell. And, Kenny the Cheese was highly indignant at having to share a trial with her.
I mean, girl, same. But Willis didn't blink, so Chesbro pleaded out, followed almost immediately by Powell. And then Chesbro sat down with investigators in Wisconsin and Michigan and Arizona and Nevada to spill the beans on all of his co-conspirators. He wouldn't get any more indictments. And it's more or less worked so far. 7 Trump world figures did get indicted in Arizona last week, but not the Cheese. He did appear in the complaint 48 times, which is, more than anyone else, kind of suggesting that perhaps some of their information might have come from him. But he did appear in that complaint 48 times, which is more than anyone else. But it didn't show his name. He appeared under the nom de snitch of unindicted co-conspirator number 4.
Yeah, he dropped all the dimes. He's like a broken piggy bank with just change spilled everywhere.
Yeah, although not perhaps in Michigan, because it turns out he was somewhat less than candid with investigators in Michigan, since Plum forgot to mention that he had a secret Twitter account under the handle Badger Pundit, because he's from Wisconsin. He used this account to take a whole bunch of really radical positions, which were sort of at odds with the story he was selling in Michigan. He tried to tell them that he was led down the garden path by the Trump campaigners, that the Trump campaign said, oh, well, these are just contingent electors, just in case that Hawaii scenario comes to pass and some, state legislator swoops in to save us. I mean, he said he told the investigators, I would never say that Pence could just toss out electoral votes. At the same time, Badger Pundit was tweeting out in November of 2020, hey, Pence can steal all the electoral votes. It's totally cool and totally legal.
Badger my ass. It's probably Milhouse. Anyway, I love how Cheese's lawyer tried to play it off to CNN by saying, well, when he was doing volunteer work for the campaign, he was very specific and hunkered down into being the lawyer that he is. And he gave specific kinds of legal advice based on things that he thought were legitimate legal challenges versus Badger Pundit, who is this other guy over there just being a goof.
He's like a whole Dr. Jekyll and Mr. Hyde kind of guy. I'm not sure about the wisdom of telling this kind of fibs to the prosecutors when they've said, you tell us the truth and we will not prosecute you, Mr. Chesbro. But look, it does not appear at the moment that the Michigan Attorney General would like to prosecute him. Still, kind of a dumbass move. not as dumbass as our next guest.
Please say John Eastman. Please say John Eastman.
Ding, ding, ding. It is John Eastman, who honestly, that guy wishes he had Chesbro's brains.
Yeah.
Eastman got himself indicted again in Arizona. Thanks, Ken. And meanwhile, he's lost his bid to keep his law license in California. And meanwhile, he's lost his bid to hold on to his ability to practice law in California while he tries to convince the state bar not to disbar him permanently.
Right.
So here's the backstory. On March 27, Judge Yvette Rowland recommended that Eastman be disbarred for his, role in flogging insane election lies. That recommendation goes now to the state Supreme Court, and Eastman will have a chance to contest it. But in the meantime, his license to practice law got placed on immediate inactive status. So Eastman moved for a reprieve on the theory that he's got to go out and earn a living right now to fund his criminal defenses in Georgia and now Arizona.
I mean, look, that's not a terrible argument, right? He did just come off a weeks-long trial in the disbarment proceeding. I cannot imagine what that cost him, but then I remember, again, his go grift me is $1 million. So, yeah, he's probably, in the black on this deal.
Oh, my God. He's so far onto that wingnut welfare gravy train. I cannot worry about that guy. He can go speak at Ginny Thomas's affinity groups or whatever and charge $20,000 a pop for his appearance.
Yeah.
He will be fine. But now let's talk about your favorite environmental lawyer and mine.
Jeff, we'll call you if there's an oil spill, Clark.
Yes, one and the same. El Jefe did not get indicted in Arizona. He's just got the one indictment so far in Georgia, although he was unindicted co-conspirator 3 in the Trump election interference indictment. And he did get a bar complaint in D.C.
Yeah. Am I remembering properly that Clark tried to get his bar complaint removed to federal court and or dismissed under the theory that D.C. isn't a state, and so its bar isn't a state bar, so it can't discipline a federal employee if there's gold fringe on the flag. And right.
Yeah, he even appealed that fakakta theory up to the D.C. Circuit, which, obviously laughed him out of the room because that's ridiculous. So he's been going through some things like John Eastman, although on the opposite coast. Well, sort of not like John Eastman, though, because Clark mostly took the fifth during his disciplinary hearing, and Eastman took his hearing as an opportunity to prove that his garbage election fraud claims were true.
That was 100% our boy John Eastman doing, trained SEAL tricks for the MAGA idiot followers who kept tweeting throughout the proceedings about how Eastman had proven that the election was really stolen. And on Planet Sanity with, the rest of us, Eastman's little backflips for fish, right? Which I should point out included calling torture memo author John Yoo as a character witness. You can't make this up. Anyway, that just gave Judge Rowland more evidence to conclude this data is facially not credible and widely debunked. And the things that Eastman's pointing to as potential fraud are not proof of actual fraud, let alone fraud, which could have affected the outcome of the election, which, definitely would have hurt Eastman if he were trying to win, which I don't think he was.
Oh, that's funny. I do think he was trying to win. I mean, I think he really is trying to win. I think he's sort of, let's say, inflexible in his thinking. And I think he thought if he presented this, what he's convinced himself is statistically real evidence, it might actually do it. But even if he didn't think that she was going to fall for the evidence, I really do think he was saying, well, my actual belief in this, garbage evidence vitiates the harm that I did.
Oh, I think the way that he has seamlessly moved from fraud to irregularities, and particularly when he's around people who can call him out, when he went on our buddy Larry Lessig's podcast, I think he knows he's shoveling bullshit with, But
wait. So I just want to disambiguate that for 1 second, because when you're talking about the fraud to irregularities, that's actually kind of an interesting thing that's happening here. And since we're talking about these lawyers, right? So in the beginning, they were like, well, there's fraud, and statistically, you can prove that Biden couldn't have won, and it couldn't have been whatever, right? They tried to sort of imply, well, first they said we have evidence of fraud, and then they didn't find any evidence of fraud, and then they did all of these garbage statistical analyses, whatever. That's not a thing, right? You can't. Yeah. You can't use that. And then they moved the ball once again to say, well, because it was COVID and all of these secretaries of state changed the ballot access rules to make it easier to vote, or they did vote registration in the park, or they didn't check the signature match well enough, that those changes made it too easy to vote, and thus increasing ballot access increases the fraud, and thus we win and you lose. I mean, it's like a stupid argument, but what you're saying is those things actually happened. The changes to ballot access actually happened. And you were saying you infer from when John Eastman is with like people whom he thinks are his intellectual equals, he cuts the bullshit about the statistical analyses and just points to these changes to the law and says, well, this is, prima facie evidence of fraud.
Yeah, that's exactly right. And all of those changes, to the extent that they were litigated, were upheld by courts, right? As within the legitimate authority of either secretaries of state, right, or the responsible executive branch officials, or in some cases, he's critical of state Supreme Court opinions interpreting the law itself, right? Like in Pennsylvania. So it's a big shell game, and that's what they're left with is you changed the rules on us because there was a worldwide pandemic, and that makes it unfair, that makes it fraud vitiates everything, therefore Trump is president.
Yeah, I love that their big argument is like, oh, you made it too easy to vote, and then we lost. Unfair. But okay, let's get back to Jeff Clark for 1 second, because D.C.
Oh, okay.
D.C. has a slightly different procedure from California. So Clark's case was heard by a 3-member panel, not a single-member judge, and the panel has not yet issued a decision, in part because Clark dicked around with his stupid, field trips to the D.C. circuit. But whatever. After the panel issues its decision, that will go to the D.C. Court of Appeals for approval. Mm-hmm. This week, the Disciplinary Council produced its recommendation to the hearing panel, and that recommendation was harsh. I'll just read a bit from the first couple of pages. So it starts off with a comparison between Bush v. Gore in 2000 and what happened 20 years later. So they say, the lawyers who litigated that election contest, that is in 2000, although under tremendous pressure, carried out their responsibilities in the noblest traditions of the profession. When the Supreme Court put an end to the litigation, the lawyers shook hands and Vice President Gore conceded the election.
Let's not get carried away. I mean, was this opinion written by someone too young to remember the Brooks Brothers riot?
That gave us Ted Cruz.
Yeah, those people deliberately stopped the count in Florida to ensure that Gore wouldn't win. Like, you may infer, I'm still a little mad about it.
Yeah. So, all right, you are not wrong here, but I do think it's instructive to separate what happened here from 1800 or 1960 or 2000, because in some sense they're right. Like, this is qualitatively different. In 2020 was not the same at all. Okay, so continuing. The lawyers who contested the 2020 election on behalf of President Trump, far from upholding the noblest traditions of the profession, betrayed their ethical obligations. At President Trump's direction, they employed any means necessary to keep him in office. This included frivolous civil rights actions filed in federal court seeking to set aside the results of lawful elections. It included dishonest legal advice to Vice President Pence in an effort to persuade him to unilaterally reject certain states' slates of electors and delay or recess the electoral count during the January 6, 2020 joint session of Congress. It also included Jeffrey Clark's attempt to replace the leadership of the Department of Justice so that he could, as acting attorney general, make dishonest representations about findings of election fraud and irregularities in an attempt to have certain states send 2 slates of electors to the January 6 joint session. These efforts all failed because the legal profession proved to be an insurmountable barrier to these lawyers' misconduct.
I mean, let's not, sprain ourselves, patting ourselves on the back about the ethics of the legal profession winning out here. Like, if Rich Donahue had, but I'm going down a long, well-trod rabbit trail.
I mean, I'm not going to go rabbit trailing too far on this, but I don't think this was the legal profession, right? It happened to be that the lawyers that Trump had put in charge of the Justice Department and the White House counsel's office said they would resign en masse, right? I don't know that that was the legal profession. I think, to be clear, I don't think that the legal profession has restrained these people at all, right? If it had restrained them, they'd have had fear of God in the first place. They'd have had fear of getting disbarred in the first place. Here we are almost 4 years later, and we're still arguing about should Jeff Clark and John Eastman still be entitled to practice law? I don't think that was the legal profession. I like to think that we've learned a couple of things since then, but
yeah, I'll tell you what Donald Trump has learned. Donald Trump has learned that there will be no more Steve Engels or Rich Donahue's lifelong Republicans in his next administration. They will all be Kash Patels. They will all be sycophants who
Jeff Clark's
will not blink. That's exactly right. And so, I'm with you. Lock them up. or in this case, disbar him,
Yeah.
but also lock him up in Georgia.
Okay. So we have one more lawyer to catch up with. That's Kraken alum Stephanie Lambert-Gentila. We wrote about her a month ago since she managed to get herself indicted in Michigan for her role in the breach of voting machines there. And after which she failed to show up at 2 hearings and found herself arrested in D.C. when she appeared as a lawyer in a related case. So if you are a Patreon, strap in because this is going to be a fun one. And if not, you can become one today over at patreon.com/lawandchaospod, where you'll get the extended episode ad-free. You can hit us up at Substack at lawandchaospod.com, or we will see you back here in a minute after we pay some bills.
All right, Liz, for our second story, let's do a deep dive into weed.
Blaze it.
Okay, but before we get there, let me be honest. Like this is really a segment about the progressive accomplishments of the Biden administration.
Of which there are many.
Yeah, right. So last week, Liz, you and I wrote about that anti-vax loon, Robert F. Kennedy Jr., right, and his war on the First Amendment. And you know, if you're not already, you should be signed up to read our Substack over at lawandchaospod.com. There's going to be a lot more writing there from you and from me.
Yeah, that was a fun one. Not least because it involved Bobby Barnes, lawyer extraordinaire.
Okay, but like in my portion of the piece, I was going to say I tiptoed around the you should be excited to vote for Joe Biden, but like let's be honest, you cut all of my you should be excited to
Don't
vote
tell them
for
that,
Joe
God.
Biden. Oh, you're a harsh editor, I'm telling you. Anyway, look, I know right now college campuses are being rocked with protest. Like my child Alex is in the middle of one, right? And recent polling suggests, and I'm going to link it in the show notes, it described young voters' interest in the upcoming election as, real quote, off the charts low. So,
it's tremendously upsetting. I too have a child in college, and sending in SWAT teams to beat up kids is just, it's horrifying. But okay, that's not what we're talking about today.
Yeah, and look, on some level, I do get the like baseline dissatisfaction with Biden, like because after passing the landmark infrastructure bill in 2021, an unquestionably good thing. After getting us out of COVID, an unquestionably good thing. Like Democrats then lost the House.
Look, we have the filibuster, and it just is. I also think that we should get rid of it, but we have Manchin and Sinema. That just is.
Yeah. So passing laws, this is really a fair test of, Biden's presidency. So let's talk about the two areas that he unequivocally can do stuff, right? And those are, one, his appointments and nominees, and two, his executive branch, right? And on both of those scores, Biden has really walked the walk with progressives. So I want to break both of those down. First, Biden's judicial nominees are overwhelmingly women, racial, or ethnic minorities. His cabinet is historically diverse. He has installed genuine progressives at the head of executive branch agencies.
Yeah, I mean, I agree with you, although I think a lot of people don't think of Pete Buttigieg as a super genuine progressive. I mean, he's not Lena Khan. But, okay, yeah, I would agree with you. And I know where you're going. Like, let's do talk about some of these policies because they make a huge difference.
Yeah, so, okay, I know you want to get to weed.
I mean, who doesn't?
Well, I would like to talk about two labor rules that have come from the
Before we get to
Department of
weed,
Labor.
we're going to talk about labor. Are you kidding? Like, you just got here. We're off on rabbit trails. No, I'm kidding. I have an inkling. I have heard in the grapevine that your rabbit trails have been sorely missed.
Aw. So on April 23rd, the Department of Labor issued 29 CFR Part 541. And put simply, what that does is increase the minimum salary that an employer must pay their employee in order to classify them as exempt from overtime under the Federal Fair Labor Standards Act. That's 29 U.S.C. 201 et sec. It basically doubles it from $17 an hour to almost $30 an hour. At the same time, on the same day, the Federal Trade Commission effectively banned non-compete clauses in employment contracts. And both of those will make life considerably better for workers, particularly lower-income workers. So if you're a paid Patreon, you'd not only get the ad-free version of the show right now, you would get an extended deep dive on both of those final rules. So sign up now over at patreon.com/lawandchaospod.
All right. And if not, we will see you back here in just a minute. Okay, that was fun, but I think it's time for some weed.
Yes. Okay. So as apparently some of us on this podcast know, marijuana is legal for recreational purposes in 24 states, the District of Columbia, and for medicinal purposes in another 14 states. You know what? Like, I'm going to interrupt. Like, I joked there, but like, there are valid medicinal uses for marijuana, right? Like,
and that's relevant to this story. Yeah,
it is indeed. Although, as a historical matter, right, legalizing marijuana for medicinal purposes has been the gateway to full-on legalization for recreational use.
Did you say gateway? You continue to be older than me. Like, it doesn't matter which venue, you continue to be older than me.
Oh, I am scared straight from childhood. I can crack an egg into a frying pan if you want.
You guys probably, if you're under 50, you probably don't remember these ads that they would play for us when we were kids to kind of scare the shit out of us. And they would crack an egg into a giant sizzling frying pan and they'd be like, "This is your brain on drugs, kid." And she'd be like, "Wow, that seems like a good breakfast." But if you're over 50, you should definitely show it to your kids because they will think it's hilarious, particularly if they've been smoking pot. No, just kidding.
Look, and from a political standpoint, right? Something like, I don't know, 400 electoral votes worth of states have legal weed, right? But one of the things that's an actual impediment here is that marijuana continues to be classified as a Schedule I controlled substance for purposes of federal law. So why don't we unpack how that works?
Okay. So in 1970, Congress passed the Controlled Substances Act, which, in your honor, I'm going to read the statutory number. It is 21 U.S.C. Section 801 et sec. That, in turn, provided for 5 categories of controlled substances, referred to as Schedules 1 through 5 in descending order of severity. So Schedule 1 is reserved for the substances with a high potential for abuse and no currently accepted medical use, and a lack of accepted safety for use of the substance even under medical supervision. So LSD is currently Schedule 1. I know that many people have different feelings about it, but
heroin is also Schedule 1.
Right. Schedule 2 is for drugs that can be abused, such as cocaine and methamphetamine and oxycodone and fentanyl, but these drugs have some appropriate medical use. They still have a high potential for abuse, but they're going to give you oxycodone if you have surgery and it's fine. Right. Schedule 3 is for drugs with less potential for abuse, a currently accepted medical use, and, quote, moderate or low physical dependence or high psychological dependence.
Yeah, we might call that foreshadowing.
I mean, we would if we had never gone to high school in U.S. America.
Yeah, fair. So, you'd think that what schedule a drug belongs to would be a thing that would be fully delegated by the law, by Congress, to an executive branch agency with the expertise to determine whether a substance has accepted medical uses or not. Like, I don't know, the Department of Health and Human Services, but you'd be wrong.
FDA, right.
Right. Instead, what Congress did was list 112 specific drugs and chemicals as Schedule I substances. That includes marijuana. And then there's this overly complicated procedure for moving substances on, off, or between the schedules, right? So first, Health and Human Services has to issue comments on any proposed scheduling. And then either Congress or the Drug Enforcement Administration must, quote, consider those comments and then decide what to recommend. And then, DEA issues its recommendations. And the DEA is the branch of the Department of Justice charged with criminal prosecutions for drug crimes. So, you might correctly infer that that's a thumb on the scale for not moving stuff off of schedules. And, it helps explain why marijuana has stayed a Schedule I drug for so long. And look, although it might not smell that way if you, say, walk the streets of Baltimore.
I don't know what you're talking about.
The Controlled Substance Act actually supersedes and preempts state law to the contrary. So it does not matter. You could be in a legal weed state like Maryland. You could be in a medicinal use state like Utah. That's really the case. If you have pot on you right now, you are technically guilty of violating federal law. That federal law is 21 U.S.C. Section 844.
Is it?
You did it. I had to, right? Who are we kidding? I put that. Anyway, Section 844 says that it shall be unlawful for any person knowingly or intentionally to possess a controlled substance unless such substance was obtained directly or pursuant to a valid prescription or order from a practitioner while acting in the course of his professional practice. And if you're thinking, hey, that says valid prescription, and I've got this prescription here from, Dr. Feelgood at the 420 Institute, like, remember that for Schedule I drugs, Congress has just declared by fiat that they have, as you pointed out, no currently accepted medical use. So you may have that prescription, but to Congress, that's not a valid prescription under federal law.
Way harsh, Ty. But okay, remember, here's the section in the script. Look at me. But remember that 21 U.S.C. Section 844 does not enforce itself. So obviously, you need a prosecutor to bring charges. And during the Obama administration, as states were legalizing weed, the Obama Justice Department issued a series of memoranda which provided guidance to prosecutors as to basically how not to prosecute people for possession of marijuana, because, like, who gives a shit? We have real problems.
Right.
But then in 2016, something terrible happened, after which every single one of those sentencing memoranda was repealed. In fact, Jeff Sessions, who famously said that good people do not smoke marijuana, drafted a lock them up memo immediately upon taking office as the Attorney General. And he said, in the Controlled Substances Act, Congress has generally prohibited the cultivation, distribution, and possession of marijuana. It has established significant penalties for these crimes. These activities may also serve as the basis for prosecution of other crimes. That is, they can, bump you up to a felony. These statutes reflect Congress's determination that marijuana is a dangerous drug and that marijuana activity is a serious crime. In deciding which marijuana activities to prosecute under these laws with the department's finite resources, prosecutors should follow the well-established principles that govern all federal prosecutions. And then there was a reference to an opinion from back in 1980. So this was an order to go back to locking up black and brown people for smoking pot.
And that was received loud and clear. From 2017 to 2020, the Trump administration prosecuted and convicted 1,845 first-time offenders for possession of marijuana. And of those 1,845, 1,250 were immigrants. Nearly all of them were black or brown. I mean, here's the best way to think about it. Of those 1,845 first-time offenders prosecuted by President Trump and sentenced for simple possession of marijuana during the Trump administration, only 125 were white American citizens. So, not hard to see how the drug laws were weaponized against the people that Donald Trump promised that they would be weaponized against.
Yeah. But then in 2020, a very nice thing happened, which is when we elected Ice Cream Joe Biden, and he appointed Merrick Garland, and the DOJ more or less gave up on prosecuting Section 844. And on October 6th of 2022, Biden issued a nationwide pardon for anyone with a prior offense, convicted or not, for simple possession of marijuana. And as part of that announcement, Biden directed the HHS to start the long process to review reclassification of marijuana out of Schedule I, which is how we got here today.
Yep. HHS completed that review on August 29th of 2023. They recommended to the DEA that marijuana be reclassified to Schedule III, which again, as you told us, are those drugs with less potential for abuse, a currently accepted medical use, and moderate or low physical dependence or high psychological dependence. And that started the next phase of the review process. And then, 2 days ago as of this recording, April 30th, 2024, the DEA formally agreed with Health and Human Services. And that finally paves the way for a final reclassification. So this process moves towards what is called the final rule, right? The two previous labor rules were final rules, right? So there has to be a public notice and comment period. There's got to be a final review. There's got to be more fact-finding. All of that is pursuant to the Administrative Procedures Act, as we've talked about, in order to keep it bulletproof from the people who will file a lawsuit as soon as this classification is changed and make sure that it goes into effect. So it's going to take a few more months, but hope is on the way.
Yeah, I gotta say, like, who's going to file that lawsuit? You know that it's going to happen, and you know it's going to be in Texas in a single-member district. But like, what is your standing to be like, oh, I don't want marijuana? It's illegal. I mean, I guess it'll be like red state AGs, and they'll be like, this is a gateway drug and you're corrupting our kids' mind with the woke weed or whatever the hell it is. But it is an interesting exercise to imagine who, besides like private prison wardens or something, is going to have standing to say, you know what you need to do? You need to keep this drug, which is consumed by, millions of people every single damn day. You need to keep it illegal, so you can fill our prisons.
Yeah, I don't know which private parties will think they have standing, but I have a pretty good feeling that the Alliance Defending Freedom will offer to represent them.
Yeah, for sure. That's Josh Hawley's wife, the group that, got rid of abortion for all of us and is coming for mifepristone, the medical abortion drug. But okay, I do take your point. We've gotten a little far afield. You're right? None of this happens without Biden getting elected.
Yeah, and let me articulate, I don't want to harsh again, but here's the specific danger. It's another one of those procedural laws that I'd love to get into the weeds over and love to hate.
Is there going to be numbers?
Yes. It was the centerpiece of Newt Gingrich's 1996 contract with America. It is called the Congressional Review Act. It is 5 U.S.C. Section 801 et sec. And what the Congressional Review Act does, it allows Congress to explicitly disapprove of any recently enacted agency rule, right? And, the timing is, believe me, this will fall within the timing. And the statute allows them to bypass the Senate's filibuster procedure. It's like written into the law. So here's what that means. If Trump wins in 2024 and has even 50 votes in the Senate and a 1-vote margin in the House, he can instantly undo the reclassification and start us all back over at square one. And look, even if Republicans retake the White House without winning both houses of Congress, the next president can, just instruct their DEA to stick marijuana back into Schedule 1.
That's a major buzzkill. And I got to say, Don Jr. is not going to be happy.
Yeah. Okay, sure. But here's the point, Liz. This already happened. Not with weed, but with respect to the Department of Labor rule. Like back in 2016, the Obama Department of Labor increased the salary floor for purposes of overtime. It was basically the same rule that Biden's DOL just promulgated, right? And the second Trump got into office, he got Congress to disapprove of that rule. It will happen again if Trump wins in the fall.
Yeah, it's hard to know as somebody who covers Trump all of the time, like what portion of the time should we spend talking about the danger that he poses to all living things, and what portion of the time should we spend talking about policy? And as somebody who's not a policy reporter, I mean, I'm really glad that you're here, generally speaking, but I'm really glad that you're here to remind me that Donald Trump cannot blot out the sun. Like, there is important stuff to talk about that's not his legal cases, as engrossing as they are, but to talk about the good things that are going on, like the good policy wins. So I'm glad you're here.
And I want to say the rule of law, accountability is still really, really important to me. So, it's not like I'm not still following those Trump criminal cases.
Uh-huh. All right. Well, vote for Ice Cream Joe, kids, and we will see you in a couple of days on Tuesday.
See ya.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.